With your kind permission, madam, can we start?
Yes, sure.
Okay. Good morning to all. Welcome you all for a national level webinar series to the year number 2020. Today we are in the second day, session 3. Today we are beginning with the doctor's role in legal procedures by Dr. D.O. Sunila, madam, the professor in the HOD Department of Agadatantra Evam Vyavahara Ayurveda, a D.Y. Patil College of Ayurveda and a Research Center, Pune, Maharashtra. So let's begin for the welcome speech. Myself, Dr. G. N. Kannoli, the Assistant Professor, Department of PG Studies in Samhita Siddhanta, SVMAMC, ILKAL. First and foremost, in my privilege to welcome with the blessing of His Holiness Sriman Niranjana Pranava Swarupi Guru Bhanta Swamiji, as event started with the Swamiji blessing. To welcome you, Swamiji. I welcome today to our SVMVV Sanghas Chairman, Secretary, all the board members for providing an opportunity and support to organize this national webinar series Hrudaya Nava 2020. Welcome you, sir. I welcome to our speaker. I welcome to our today's speaker, Dr. D.O. Sunila, madam, the professor in the HOD, Department of Agadatantra Evam Vyavahara Ayurveda, a D.Y. Patil College of Ayurveda and a Research Center, Pune, Maharashtra. Madam is going to continue the talk on doctor's role in legal procedures. Welcome you, madam.
Thank you.
Thank you, madam. I welcome to our event president, Dr. K.C. Das, sir, the principal and CMO of SVMAMC ILKAL, for his kind-hearted care and the backbone of this national level webinar series 1 for the year 2020. Welcome you, sir. I welcome to event organizer, Dr. L.K. Pattar, sir, the associate professor and the HOD, Department of Agadatantra Evam Vyavahara Ayurveda, SVMAMC ILKAL. Welcome you, sir, for the organizing a national level webinar series to the year 2020. I welcome to event coordinator, Dr. Manjula P. Sarganachari, madam, the associate professor, Department of Agadatantra Evam Vyavahara Ayurveda, SVMAMC, for your support and the conducting the national level webinar series 1 to the year 2020. Welcome you, event coordinator. I welcome to all the teaching staff and the non-teaching staff, PG and UG scholars, internees of SVMAMC, PG Research Center, ILKAL, for supporting and being the part of this national level webinar series 1 to the year 2020. Welcome you all. I welcome the Department of Agadatantra Evam Vyavahara Ayurveda, D.Y. Patil College of Ayurveda and Research Center, Pune, Maharashtra, for their support and being the part of the today's national level webinar series 1 to the year 2020. Welcome you. I welcome all the teachers and the PG, UG scholars of other institutions, especially D.Y. Patil College of Ayurveda and Research Center, Pune, Maharashtra, SVM Ayurveda Medical College, participants watching in YouTube, SVM Ayurveda Medical College, ILKAL, participants watching in YouTube, for being the part and participating in the national level webinar series 1 for the year 2020. Welcome you all. As the Krishnaveni Nadi is near to the Punatambe, Namami Sukritam Shredim Krishnavenim Taranginim, Yadvikshanam Koti Janmakrita Dushkarmana Shikshanam, Guru Kanyagatam Dhanya Yapuraskritya, Sevyase, Shri Krishnaveni Papani, Satvam, Punyayasi Dhruvam, Kim Varnayami He Krishnatvayi, Krishnasta Sannidhim, Yat Samasta Padokto tu Kumbhava Mamalam Base, Shri Krishnaveni Kalyani, Yache, Vam Ahan Vaham. Shri Krishna Charanamboje Bhakti Bhaktavachiri. As the speaker belongs to the Pune, so now I request to Ms. Rupa Teggi, third year UG scholar, for introducing the today's guest speaker. Over to you. Thank you, madam.
Hello, sir. Am I audible?
Yes.
Good morning, one and all. Myself, Rupa, third year UG scholar. It's my great privilege to introduce today's guest speaker, Dr. Sunila Dio, madam. Madam completed MD IU with a Dravya Guna specialty and MA in Yoga Shastra. Ma'am have a teaching experience of 20 years in various institutions and PG teaching for 9 years. Ma'am is also a PhD guide since 2020. Presently, ma'am is a member of Board of Studies, Faculty of Ayurveda, Academic Council for Dr. D.Y. Patil University, Pune. Ma'am is also published 6 research papers in peer-reviewed journals. Ma'am is working as a honorary physician at Padsad, Karnapatir Vidyalaya for specially abled children at Nashik since 9 years. Ma'am is specially interested in Panchakarma, controversial medicinal plants, Yoga Shastra for mental and spiritual health and human behavior. Ma'am is presently working as a professor and HOD Department of Agada Tantra and Vyavahara Ayurveda at DY Medical College of Ayurveda and Research Center, Pune. I heartily welcome you, ma'am, for today's session on the topic doctor's role in legal procedures. Thank you, ma'am.
Thank you. Shall I start?
Yes, please, madam.
Suprabhatam to everybody. Om Gang Ganapataye Namaha. Shri Dhanvantaraye Namaha. या कुंदेंदु तुषार हार धवला या शुभ्र वस्त्रावृता या वीणांवर दंड मंडित करा या श्वेत पद्मासना या ब्रह्माच्युत शंकर प्रभृत्रिभि देवै सदा वंदिता सामां पातु सरस्वती भगवती निशेष जाड्यापहा. Remembering the god of Vidya, आदिदैवत
वो नहीं करती मतलब
गणानाम अधिपति गणपति Dhanvantari and Saraswati Ma, we shall start the today's discussion. Today we are here gathered together on this platform to discuss the doctor's role in legal procedures. As I had discussed with Dr. Pattar sir, he had given me a choice to select the topic as per my choice, and the session was intended, as he said, for the UG students especially. Okay, still, but as I have gathered the information from your previous sources, the video circulating for the welcome and previous 2 lectures, I have come to know that except AGAD Tantra, so other department PG students are also there for whom they have joined here the session and for whom this session will be also useful. I sincerely thank Dr. K.C. Das sir for inviting me for this session as a guest speaker. I wholeheartedly congratulate Dr. Patta sir, Dr. Manjula madam, and Dr. Kannoli sir for the huge efforts they have made to make this event a grand success. They have really made the huge inputs so as to bring out this event as an outcome. I really congratulate them. I even thank SVM College of Ayurveda and Research Center so as to give me this opportunity to interact with you and have a good venture. So with all this, now let us go for our topic. Students right now who have joined this session are not doing post-graduation in Agad Tantra. They are either postgraduates of other streams, or they are the scholars in other streams, or either they are UG students. For them, let us have a brief revision of what they learned in their third year session, third year topics which were under the legal procedure. They had learned about the inquest. Inquest is seeking or searching something. Here it refers to legal inquiry to ascertain circumstances and cause of death. The types of inquest which we learned there were police inquest, magistrate inquest, coroner's inquest, and medical examiner system, of which right now in India, what we should know that out of these these 4 types, only 2 are followed regularly, that is police inquest and magistrate inquest. Medical examiner system has been stopped long back, and the coroner's inquest also has been stopped since 1990s. So we have significantly to know that police inquest and magistrate inquest are the two types of inquest in which we need to have a role as a doctor whenever called for. The types of courts in which we need to go as a witness are Supreme Court, High Court, Sessions Court, Magistrate Court, and special courts as per needed, and juvenile court. The types of offences which normally occur around us are cognizable offences and non-cognizable offences. And accordingly, we need to see what types of cases come in the court. They are civil and criminal cases. Civil cases deal with the civil matters, while criminal cases deal with when there is some offense occurred, which may be cognizable, and there may be an unnatural suspicious occurrence, which may have led to the event, and with that, some inquest is needed regarding the case. Regarding the procedures which are carried out in the court, what we studied in the text was there is a summons issued. As per the summons, the person goes to the court, attends the courts, and then he takes an oath before giving the evidence. Then there are 4 steps which are carried out to gather the evidence, in which there is examination in chief, cross-examination, re-examination, and the questions by the court. Now coming to where our role stands. When we are called, what we should do, that is the main theme what we are going to learn in this lecture today. When a doctor is called to give the evidence in the court, the procedure what the court follows, that we should know. A summons is issued which is in a form, means in a written form, which compels a witness to attend the court for the specified purpose and at specified date and time. That is the summons. It is in a written order. It has 2 copies. One is given to you as a witness, and another is signed by you and written back to the bail who will be coming to you. Now, what the summons has importance for you? You must obey the summons. Any order issued by the court must be obeyed, and that is a law. So you have to obey the summons. If you don't obey the summons, am I audible properly?
Yes, madam.
Is there any issue?
No, madam.
Voice is okay? Which?
Yes, madam. It's clear.
Okay. Okay, we will go ahead. If not, punishable under section 172 of IPC. That means if the written order which is issued to you as a summons, if you don't obey the order and you don't remain present in the said court at the said time, then you are punishable under section 172 of IPC. What you should know regarding the summons, that how to react to summons. Now, suppose there is a case that there are 2 summons received, then what shall I do? That is a question you should you may face in life sometimes, and then what you will do, that you have to know. If you receive 2 summons, priority is given usually to a higher court as a general rule. But whenever there is a criminal case and another a civil case, and the 2 summons belong to 2 such different cases, then the priority has to be given to the criminal case. A condition may be there that the courts are of the same level, both the cases are of the same type, either the criminal or the civil. Then what to do? That in that is solved by this third clause, that is which one is received prior is to be given the priority, means whichever is earlier received, you have to give the priority and attend the court at that according to the first summons. If the time denoted in both the summons is same, the question arises here over when only the time is same. If it says about the two different dates and two different timings, then there is no controversy. But when you receive the summons which are having the same specified date and time, then what to do? That question arises, and that has to be solved according to this clause. The higher the court has to be first attended. If the case is criminal, then you have to go for the priority has to be given to the criminal case. And then third clause will be if the one summons is received prior and the other is received later, then the prior summons has to be given the priority. But at the same time, you have to remember that whichever another summons has been received, you have to notify that court that you are attending the another place, another court, and at this same specified time, and you take the permission that you will be attending the latter one in the another timings also. So that is the rule which we have to follow as a doctor, because you have to remember you have been called as an expert evidence over here, expert witness over here to give the evidence. So in that role, you are going there and you should behave in a proper manner. That is the main motto behind discussing all these things. Then coming to the oath and perjury. Oath is a willful utter, it is an oath taken so as to tell that you will be willfully uttering the correct thing. Okay, so you are going to talk only truth, the truth itself, and truth and nothing else. And that commitment given in front of the court is nothing but oath. Usually in India, we follow that one dharma grantha of whichever dharma the person belongs to. Either it may be a Gita, it may be a Bible, or it may be a Quran, or as per the dharma grantha may change. It is brought to the court. You keep the hand on the on that dharma grantha, and you take the oath of your utterance of truth and truth only. And after taking the oath also, if you are not telling the truth willfully, then it is termed under perjury. And the perjury is also punishable, that we have to remember. But another one thing is, sometimes we face some problems to attend the court. Either it is in another city, or it is a long distance matter, or it needs some expense. In such cases, we can have a demand, or there is a tender of a fee paid to you so as to bear the expenses to remain present at the said court. So that money tendered as a fee is called as conduct money. Okay, now we have to remember that such conduct money can only be in the civil cases, and the fee tendered has to be bared by the party which is calling, by whom you are called as a witness. So that party will bear this expense and will be given as a conduct money. Conduct money, if you feel so that it is not sufficient, you can demand your actual expenses and notify it to the court that such and such thing is needed, and accordingly the changes can be done. So that is regarding conduct money, but it is only in civil cases. In the criminal cases, it is mandatory for you to attend the court even though the conduct money is not issued to you. Remember it very well. Now see, we are discussing about what is your role in the legal procedures. So whenever you are called with a summons issued to you, then what you have to do, that we should know. And right now we are discussing this thing. You will not demand any conduct money. Remember it very, very well. You are not going to demand any conduct money in the criminal cases. This is applicable only and only for the civil cases. As a witness, you will be called. There are three categories of witness: common witness, expert witness, and hostile witness. Your role is as an expert witness. A common witness is one who will be just giving the information whatever he has witnessed. Either he may have seen, he may have heard, or he may have perceived with his senses. That whatever facts he narrates, that narration given by a layman is a narration which will be having no technical expertise, and hence such kind of witness is called as common witness. You as a doctor will be observing the things, you will be analyzing them, you will be having opinions over the observed facts, and as per that you will be applying your science, and so that with this expertise of ability to apply the science, you are an expert witness. Hostile witness, okay, no question arises about you to be an hostile witness, as it will be a misconduct. So let us forget right now as a doctor about the hostile witness. I need not explain anything, because hostile witness will be maybe probably uttering willfully, narrating wrong facts or facts favorable to his party, whatever it is, and which may be not very much true. So we should forget about what is hostile for us. We are not going to go anywhere in this role. Our role is only experts witness. That's the only role which we are going to do. So accordingly, as an expert witness, we will be giving an evidence which will be either in the oral evidence form or in the documentary evidence form. Hearsay, circumstantial or corroborative evidences may not play much important role for us as an expert witness. They may be important or they may have a value for a witness given by a common expert. But you as an expert witness, the priority is regarding the oral evidence and the documentary evidences. Now, as a doctor, here we have gathered today together to know what type of evidence we are going to put forth in front of the court, and then what precautions we are going to take while presenting these type of these type of evidences as an expert witness. That is our main motto to gather over here. Rest of the chapter you have learned. I need not much emphasize on the other things. I am only bothered about, as a doctor, what evidence you are going to give, and accordingly, what are the thumb rules which should be followed for oral evidence as well as documentary evidences to be prepared by you, and that we are going to discuss in chronology. Documentary evidences, as you all know, documentary evidence is nothing but a document which will be produced as an evidence. As a medical fraternity, as a medical expert, what type of documentary evidences you may provide, that we should know. They are medical certificates, medical legal reports, and dying declaration or deposition, which are classified in the text. But we need to know, reading in between the lines, what rules we should follow, what precautions we should take while issuing these certificates. Because the reason is that these certificates may stand in the court and you will be called so as to have the testimony over these documents, as you may have issued these certificates. They may call you to verify the truth in these certificates which are issued by you. So your truthfulness may be verified, and hence we should follow very strict rules regarding the facts while issuing these types of certificates or reports. So the types of medical certificates what we usually issue are illness certificate, fitness certificate, birth certificate, death certificate, then sometimes vaccination certificates, and then certificates given for compensation so as to show what is the loss, percentage loss, which usually occurs in the industries. Like if you have sometimes gone through the Workmen's Compensation Act, you may know what exactly a compensation is. If some loss is there regarding any part of the body during the working time, then that compensation has to be given by the running authority, that is the firm which has given the employment, and at that time only the compensation certificates are the certificates for the compensation are needed. The routine given certificates, which I have listed over here in this presentation, which we are bothered about routinely presenting, are illness certificate, fitness certificate, birth certificate, and death certificate. In these certificates, what precautions we need to take, that we have to right now discuss over here. That is our main aim, to understand what we should behave as such. Birth certificates follow their own procedure. The center where the births take place, means maternity center, they follow a record of the births over there in that hospital, and they may produce, they have to give their data to the governing authority of the city, that is usually the corporation, and then they will be issuing a actual birth certificate that we know. Regarding death certificates, as a doctor, what precautions we should take, that also we are going to deal with. In illness and fitness certificates, what thumb rules, and even in the death certificate, what thumb rules should be followed, that we will discuss. Whenever you are issuing a certificate, it may be an illness certificate, it may be a fitness certificate. As we discussed in yesterday's session, it is a registered medical practitioner's job to issue a certificate. Okay, that we had discussed yesterday. Accordingly, as a registered medical practitioner, remember that you should be a registered medical practitioner. Don't forget it. If you are not listed in a register in the registration, you are not issuing a correct document. So ensure that you are a registered medical practitioner, and then only go for issuing the certificates. While issuing a certificate, take precaution that to whomsoever you are certifying, you should write the correct and full name of the person whom you are issuing the certificate, regarding whom the certificate is being issued. The full name has to be denoted. Get the identity verified. Many cases, the patient is routinely your follow-up patient. You know the patient, you know the background of the patient, you know his history, you know his family history also. Then the identity doesn't become much problem. But suddenly sometimes it happens so that an unknown person comes to you and demands a certificate. Like for example, he wants to remain absent for his workplace, or who may have remained absent for his workplace for 2 or 3 days, and then he is demanding you for the fitness illness certificate. What should you do that time? You don't know the person. Then at that time, you should demand for the identity proof of that person. You should always put a question that whichever person is standing in front of you and saying that his name is such and such, whether it is a correct fact, that you should verify always. So get the identity verified, and then only issue the certificate. Whenever you are giving a certificate, you examine yourself thoroughly to the person or the patient in front of you. It is not that somebody else will examine and then you will certify the illness. That thing should not happen. Even the fitness, you yourself should examine You should verify the facts regarding what you are going to certify, and then only you will certify. So examine yourself, that is very important. Notify the date and time of the certificate which you are issuing. Okay, so date and time when you are issuing the certificate, that has to be denoted on the certificate itself. Another main thing which you should follow and which is very important, never give any certificate in the anticipation or in the post-dated stage. You are certifying today and it is for the date 4 days later. That should not happen. 4 days later, you don't know what is going to happen. 4 days later, or a person you don't know what that person does. He may do a crime and he may give a illness certificate, and you will be charged as for contributing to the whatever crime has happened. So always take care that you will never give a certificate in anticipation or a post-dated certificate. A very nice method to get the identity of the person verified and denoted on the certificate itself is get the thumb impression of the person on the certificate itself to whom you have issued the certificate. So it is very obvious that the person whose thumb impression is there or who has signed so as that he has received the certificate over the certificate itself, which will reveal that you have certified that person whose impression is there on the thumb impression is there on the certificate itself. So there is no controversy of the name and the identity of a person. The identity can be very well identified. It will be very well verified only with the thumb impression which is there and then on the certificate itself. So that is a way of precaution to be taken by a doctor while issuing a certificate. Regarding the death certificates, again same thing. The name of the person deceased should be full. The identity should be verified. Examination should be done by yourself thoroughly. Now here in the case of death certificate, you need to verify whether all signs of death are there. You should know the cause of death, what it is, the recent cause of death. If usually the patient is a family patient or you are a family physician for the family, then you know the ailments which are occurred to that person. So you can you probably are quietly aware of what the ailment the person is having, and accordingly you can certify with the cause of death properly. The cause of death has to be denoted very clearly. Like for example, coronary thrombosis is the cause of death, or like for example, respiratory failure is the cause of death, which may have been caused due to, that also has to be denoted. Like for example, respiratory failure may have been caused due to bronchitis, due to COPD, or whatever cause you can say so. So that immediate cause of death, which may have been caused due to which ailment, all those things are to be specified in the death certificate very, very clearly. And one more thing regarding the death certificate. Whenever you have a suspicion that the death is not natural, now this suspicion, when it will occur, when you are examining thoroughly yourself. You may examine for the signs of death, as well as you should examine externally all the thoroughly through the external surface of the body. You should very minutely always observe regarding any marks over the body, any injuries over the body, especially around the neck. They are to be also observed. Then any discolorations, any injury marks, any contusion marks, especially over the neck or backside of the head. Then any puncture marks, needle puncturing is seen over the skin. All such marks are thoroughly to be examined over the surface of the body, and then you remove your suspicion totally that nothing unnaturally has happened, and then only you are going to issue the certificate. If you find any suspicion while examining thoroughly, you should withhold giving the certificate. Now, this is very, very serious. You have to remember this very seriously, that whenever there is any suspicion, you are not going to issue any certificate. We remember very well. Whenever there is a suspicion to you that the death is not natural, you don't know the previous circumstances, there is a suspicion that you find some injury, you find some marks, or you find some fishy thing in the circumstances around at the circumstance as in circumstantial evidence, you should withhold giving the certificate. You always in such condition are expected to inform the police immediately. Okay, so withhold giving the certificate, inform the police immediately, and just forget about issuing the certificate now. Once you inform the police, it is a medico legal case, and then and when wherever there is a medico legal case, naturally it will be sent for post-mortem so as to get revealed from the suspicion aroused, and then for that the post-mortem is done, and accordingly the report will be generated for post-mortem. So your role during doing the practice in your clinic is only regarding issuing certificates. Whenever you are running a small clinic which is not having any indoor facility, you are only running an outdoor facility clinic, or elsewise a panchakarma center, or some facilities which can be given only at OPD level. If you are running such a center, then you are responsible usually only in issuing certificates. Going to a next scenario where you are working in a corporate hospital or probably in a government hospital, many a times a situation comes where you need to give medical legal reports. Now, remembering the theory of medical legal reports are reports generated by a medical man, means that is a doctor, whenever demanded by or required by a legal entity, that is either the police or a magistrate. When they demand for a report from after examining the medical conditions from a doctor, then only we need to prepare medical legal reports. Such situation arises usually when there are medical legal cases. So in such scenarios only, a doctor needs to write a report. As you all know, a report comprises of 3 sections. A doctor is entitled to furnish all the information in all the 3 sections of a medical legal report. The 3 sections are the preliminary data of the person whom you are going to examine, that preliminary data. Second section will comprise of the observations which you have denoted, and the third section will be regarding the inference drawn from the analyzing the observations which you have done. Okay, so you have to fill the report in detail. You are not going to leave any column. Like for example, everybody has seen the post-mortem report. On the very first page, you see that there is a preliminary information of the patient or a deceased person, the name of the person, the age of the person, from which area the dead body has brought in, or like for example, even the person who has brought in, all those information that has to be furnished in the preliminary section of the report. Regarding medical legal reports, it is not only, one more thing you have to remember, that it is not only the post-mortem reports which you need to issue as medical legal reports. There may be an age report, there may be a examination of victim or examination of accused in the case of rape. All such reports which comprise of a series of observations done and an inference drawn from the observations, such kind of reports are included under these medical legal reports. So all such types of reports which may have a specific format or which for which you may need to create a format. All such reports which contain a series of observations done precisely and an inference drawn from the observations, all such documents will be termed as or will be classified under the reports that you have to remember. So now, what rules you will follow while filling up this 3-sectioned format or of the report of medical legal issue case? Either it may be a postmortem report, it may be a examination of victim of or accused in the rape, or examination of the injuries occurred. All such reports. While preparing such reports, what rules you should follow, that we are going to discuss right now. Remember very well, such kind of medical reports, you are not going to take risk while you are running a small clinic. Don't go in such matter, because medical legal reports are issued only when the cases are medical legal, that is in the case of MLC. So as an individual, as a person who is running an individual clinic, let us not go in these details. The person who is working as medical officer, you may land in such scenario in the future. You may work somewhere as a medical officer in a government hospital, or in a corporate hospital, or in an indoor hospital which is having a number of cases admitted. And sometimes the medical legal cases are admitted over in your hospital. That time, this situation you will have to face. That time, what you are going to do, that we should know very properly. Now, thumb rules for issuing such medical legal reports. Examine properly. Examine the case very properly. Either it is a dead body or it is a living person. Examine the person very thoroughly. Each and minute thing has to be examined. Like for external appearance, when you are going for an examination, everybody knows what an PM report is. Usually what we do, we go for an external appearance to be observed first, and then we go for the dissecting and going for the observations which are to be done inside the body. So while examining externally, for example, you should examine from head to toe. What about hair? What about face? What about something on the neck? What about something on the chest? What about on extremities? Is there any mark of injury? Is there any mark of puncturing? Is there any discoloration? Is there any mark of violence? All these things you are going to examine properly, very, very thoroughly. Okay. So very first step will be examining very properly whatever observations are there. Then you have to write down the observations, what you have done in this examination. Write the observations precisely. Means, like for example, there is a mark of injury on the forearm. If there is a mark of injury on the forearm, it is of 2 centimeter length and maybe probably half centimeter width. So that precise measurement has also to be denoted while writing the observations precisely. That is the meaning of this statement. You have to be very precise in writing whatever observations you have done. So what are the facts, observe them as it is and write them as it is. Okay, don't make any changes with your thoughts. Don't think over the things. Just note the facts and write them down as an observations very precisely. Another rule which you should follow, note immediately. See what happens. If you are examining a body and then you are planning to write all the observations together after 1 hour, after the thorough examination of the body, you will forget everything. If you are writing something about what has happened, what you have seen externally on the body, and then later on you are just going for the dissection, you are going to, there is probably a mark on the chest and you have not noted it. You have just noted it in the mind and you think that you are going to write it very correctly after 1 hour, after doing the total dissection. No, don't do like that. whatever you observe, note down immediately, because you may destroy that circumstance, or probably you may not remember what exactly as it was. You may probably miss the degree of what observation you have done to note it properly, and then later on you may either exaggerate it or you may undermine it, and you write the observation. Such thing can happen if there is a time lapse for denoting the observations. So note all your observations immediately without wasting the time. Usually while doing PM, we follow these rules that we note it immediately. We are not going to note all the things later on. Okay, so that rule also you have to follow. Then next rule is no exaggerated statement. See, we will take the same example now. There is an injury on the forearm, which you have measured already, that it is 2 centimeters probably, or 3 centimeters, whatever it is. And in the statement, while writing the observations, you are not going to write that there is a big injury on their forearm. No, don't write. It is an exaggerated statement. Denote what exactly it is. Be very precise. Don't exaggerate. Means don't overmine what exactly observation is. Don't even undermine. Don't even overmine. You represent what exact degree the facts are. So observe precisely, note them immediately, and note as the facts itself. Don't exaggerate any statements while writing all those observations. Next point is clearly mention all details. See, like for the same example, we are if we consider uh, all the details means what is the length, what is the breadth of the injury, what is the length of the injury, what is the breadth of the injury, what is the depth of the injury, what is the color of the injury, probably you will have to write. Then is there any foreign material adhered to the injury? All these details are to be mentioned very clearly while writing the report. Now, writing all the observations in such a manner that after examining properly, writing down them precisely and immediately without doing any exaggerations or undermining of the statement, and writing all the clear details, a set of observations is there in front of you as in facts. You correlate all these facts, analyze them properly, and draw an inference from the observation. That has to be written in the third part of your medical legal report, where it is denoted as inference or conclusion of the observations. It has to be analyzed and interpreted properly. All the facts you are going to analyze and interpret properly. Like for example, again taking the same example, if we think of a linear injury which is 2 centimeters, we can draw inference that there is a probably a weapon used or weapon interacted with that body which is sharp, and the type of injury which is an incised wound, that has to be written as an inference in the of the observations. So write the observations very precisely, immediately, mention all the details, no exaggerated or undermined statements, and the inference should be drawn from all these facts, and then only the form has to be filled properly. So that are the rules while we are writing about writing a medical legal report. Going further, we had listed documentary evidences in the previous 2 or 3 slides prior, that they are oral evidences, they are documentary evidences, and sometimes a dying declaration may be needed. Again, now considering the dying declaration, a same scenario you have to consider. Dying declaration is not to be taken in your small clinic. Usually such cases occur when a medical legal case or a case after an accident or an after a mishap occurs, and the person is feeling that he is nearing death. At that time, he wants to narrate something which is related to the cause of death. That time the dying declaration is taken. So it is a declaration given by the person who is supposed to or feels that his death has neared, and he wants to throw a light over the facts which are related to the death, or which are related to the circumstances which may have been as a cause of his probable death. So all such details which he wants to narrate are to be written down by a doctor who is working in the hospital as a medical officer, where he is dealing with such case of a person who is nearing, or he is feeling that he is nearing his death. Okay, at that time, what you should do? Now, what is your role? As a doctor, you should, or you are liable to note down the total declaration in such scenario. It is your job to get the declaration documented from the declarant. Okay, so your role is a vital role over here. You have to remember it. You are not going to wait for somebody else to come, for a magistrate to come, and then the declaration will be denoted. Sometimes in such waiting, you may lose the person, and then the facts also are used. So in the current scenario, you are a responsible person that you have to certify, and you have to certify the condition of the person, and then get the declaration given by that person documented. So now what you will do? Allow the declarant to talk in his own words. Okay. So whatever he wants to narrate, he will be narrating in his own words, and you are going to write down as it is what he is narrating. Okay. If the person is able to write, he is in such a condition, physical, that he is able to write, then let him write by himself in his own words. But probably in many cases, when the death is nearing, the person may not be able to write himself. You are going to assist to get down the declaration noted. So it should be noted down in the declarant's own words. Don't use your words. Use his words only, and just note down whatever words he is narrating. So declarant's own words are to be written down as a declaration, as a document, so as to be prepared. Whatever he is narrating to you, write it down in a sequence. Sometimes, if needed, you can ask few questions just to clarify, or just to make a ambiguity removed, but no leading questions are allowed. Okay, no leading questions should be asked to the declarant, to the person who is probably thinking that he is going to he is nearing the death. Such person, you are not going to ask any leading questions. So no leading questions, no questions from your side as such. Only sometimes you may ask a few things just to clarify, but nothing as like leading questions should be asked to the declarant. Now, while he is narrating something, you have to confirm whether the person is in full conscious and he is mentally sane also. Otherwise, you may write all the things what he is narrating, but he may be in a state of confusion, he may be in the state of mental illness, or he may be in a state of losing memory, whatever it is. So such mental ability, condition, and saneness of a person and his full consciousness also has to be ascertained, and then only get written the narration given by him. So confirm it and then only start writing. Okay. Then after knowing all the facts and denoting it on a paper, on a piece of paper, if he has finished, confirm whether he has finished or whether he remembers anything else to be added, confirm it, and then once he says that he has finished whatever he wants to tell, read it out again for him. Go for once again revising it for him. Read it out in a sequence for him. Whatever you have written as it is, read it out for him. If he wants to add something, he will definitely interrupt you and say that he wants to clarify something more else and he wants to add. Note down all those facts also again. So with this revision, now he confirms his declaration that it is a complete, and then make it a complete declaration, make a complete document on his side for all the evidences what he wants to give as for the facts related to his nearing death or for the circumstances which are leading to his death. Only such facts are to be noted over here that you have to remember. He may tell stories that is not related over here. Only those facts which he wants to declare, which are related to his nearing death or which are related to the circumstances which are leading to the death, that only are to be enrolled over in this document. After completing this document, duly gets signed. Now, who has to sign the document? The declarant himself will have to sign the document that he has given this declaration. The doctor who is going to note down this declaration with his pen and paper, that doctor also will sign, and a witness who is a sane and educated person who understands what is going on around him. Such a witness, an additional person who is a learned or rather a sane person who is in his senses, should also sign over the document as a witness. Every sign of all these persons should be denoted below with the full name and the address of every person in this list. All three have to mention their full name and the proper address of themselves while signing the declaration. Now, what happens if the person who has anticipated his death and given a declaration recovers later on and no death occurs and the now person is surviving? What value the document has? If the declarant survives, the document only has a corroborative value. It doesn't carry much importance because the person has survived and now can narrate the facts himself or herself. So only it has a corroborative value that you have to remember. So there is a vital role of a doctor while getting a dying declaration noted. In a declaration, it is the sole responsibility in maximum cases that doctor has to note down all the facts. He has to get all this document completely prepared and then submit it to the relevant authorities like magistrate usually. So that this is the sole responsibility of doctor. That is the role of doctor in this procedure. And this procedure is going to have a meaning, great meaning in the legal procedures later on as an evidence to be produced as a document in the court later on. And there you will be facing the interrogations in the court so as to verify the testimony of this declaration. So you should note it very precisely, very correctly. Again, same rules are to be followed. Note down the proper facts, note them in as it is words. You don't use your words to exaggerate the terms. Use the declarant words only again over here and go for the proper denoting of the facts which the declarant is wishing to declare. Okay, so that is all about the dying declaration. Remember very well, whenever you are working in a government hospital where there is a indoor hospital or in the corporate hospitals where MLCs are usually brought, or when you are working in a roadside hospital where there are n number of accidents occurring and accident cases are brought to the hospital. In such scenario only you will be needing to prepare this document. In your own clinics, probably you may not face such situation in throughout the life. So those who are running an OPD clinic only probably may not face such situation. But still there is a possibility in a very rare situation that the person has come to your clinic and probably now he has understood the nearing death, and he may have to say something. At that time also, you may need to probably note down this declaration. So in such scenario also, you will have to play a vital role as a doctor in such scenario, so as to make a legal procedure smooth later on. Okay, so that was all regarding the documentary evidences which you need to produce in the court of law. So, and while preparing such documentary evidences, what precautions you should take as a doctor, that we have discussed in last previous 3 or 4 slides, where we discussed about the medical certificates to be issued by you, the medical legal reports to be issued by you, and in the cases of nearing deaths, the dying declarations are to be denoted. That all we have discussed until now. Now the scenario comes when you are there for giving an oral evidence. You are standing in the court. You have to explain all the documentary evidences which you may have previously submitted, or previously the documents are being created by you, and the testimony of the truthfulness of the document is testified in the court of law. At that time, you are called with a summons, which we previously discussed, what you have to react as per the summons that we have already discussed. And when you receive a summons and you are now standing in the court, what sort of behavior as a medical man you should do, that also has to be very precise, and we should know what we should do. While standing in the court, how the conduct of the doctor should be there, that should be very properly known by us, and we should be very precise in following the conduct to be done in the court. Let us discuss it point by point. While going in the court, you should be a modest person, well dressed, and going there with an appropriate personal appearance. Like you are going there as a doctor. So see, and you are wearing some jaggery muggery clothes, colorful clothes, or you are in an probably a cultural attire or something else. Don't do like that. Go in a proper professional attire, properly dressed, and be a person in appearance who is having an expertise. Look like that and be modest in your behavior. That is a basic requirement as a person when you go and attend the court. You are a person, you are a witness over there, and remember very well that you are an expert kind of witness. You are not a common witness over there. You are an expert. You are called there as an expert so as to give your inference, so as to interpret the facts and give the inference and give your opinion over the circumstances or over the facts. So you are an expert witness that you should not forget any time. When you go to the court, you should maintain the dignity and show full respect to the court. You should maintain your own dignity. At the same time, you should maintain the dignity of the people and circumstances around you, and you should show the respect to the court. So in court, respectful behavior should not occur by you. That care you have to take. Whenever you are called in a witness box, remember very well that when you start your narration, you should address to the judge first, and that address should be done by the proper titles. Like, for example, my lord or your honor are the titles which are to be added initially for the judge while addressing to the judge, and then your narration should start. That should be that these rules should be followed, because judge is the presiding officer over the court, and then you should see judge or nyaya devata, what we say in our culture. It is the word itself includes devata, means the judge is considered just next to God, so that he gives justice in the court. So when you interact with God, you have a full respect. Same way, the same respect should be shown to the judge while addressing the judge when starting your narration. So that you have to remember. Like for example, when we address our God, we address him with full respect, wholehearted respect. Same way, the titles which are commonly used, like your honor or my lord, these are just to exhibit your full respect to the judge who is just next to God. Should be modest in stating qualification and experience. You should not be very having a pride, what we say, like vrutha abhiman. You should not have any vrutha abhiman while stating your qualification and experience. You may be highly qualified, but then there should be vinaya while stating regarding your experience and qualifications. You should not have any, you may be highly qualified, you may have a very good experience, a very good expertise, but while denoting or while stating about your own regarding the what expertise you have or what you're revealing about your identity, you should be very modest, you should be very lenient, you should have a vinay. It should be a savinay explanation regarding your narration, regarding your qualification and experience. So after uh, giving about your, after narrating about your identity and your expertise, the interrogation starts with the lawyer, with you, and that time be very attentive to each question. So whatever question has been asked by the lawyer, be attentive to hear that questions. Know the question precisely and exactly. Try to understand the question very in the exact manner. So to understand it, the meaning of the question, be attentive to understand that question and then answer honestly. You have to answer this question, which you have attentively heard, should be answered honestly. So you have to be very honest during your narration. That you have to remember very well while you are there in the witness box. Your speech should be very clear, easily audible, confident, but polite. You should be very clear in your narration. Okay. It should be in such a pitch that it is surely and easily audible to the judge and the people around, means lawyer of your party, lawyer of the other party, the clerk who is denoting all the evidences on a paper, and the presiding judge and all other people who are related to the case and are there in the court. All should be audible. So you should be easily audible. You should be confident in your narration of your statement, but at the same time polite. You should not when you show that you are inconfident, then it raises the ambiguity in the mind of the presiding judge or those who are narrating, those who are denoting your narrations. They will not feel that it is a very correct thing. So be confident, but be polite. Be clear on whatever you are narrating. Okay. Then next point is speak slowly so as to record the evidence properly. You should be in such a speed of uttering your words that they can be recorded down properly. Somebody always remember, somebody is writing your narration. Somebody is taking the denotions of what you are uttering. So allow him to get it recorded. So have such a speed that it is enough slow so as the person who is recording can record it properly. Okay, so don't be very hasty while giving your narrations. Be in such a speed, in such a slow manner that it can be recorded properly. While giving your narrations, use plain and simple language. See, everybody is not a medical expert around you. They are probably legal experts or experts of some other field who are there around you in the court of law. So they don't understand your technical terminology. So for that, use plain and simple language, avoid technical terms. But at the same time, see, remember very well, at the same time, you should not lose the scientific value of the statement. It should be in a plain and simple language. It should have its scientific content in it as you are an expert, and at the same time be such simple while using the language that it should avoid technical terms, because technical terms will not be understood by the other experts around you. They may be experts or lay people of some another field. They are not experts of your field, so they may not understand your technical terms. So avoid using the technical terms, be simple in your language, but be precise and don't allow the scientific meaning of the content to be lost. That you have to follow. Then avoid using superlative and exaggerations. Don't exaggerate your statements. उसको अतिरंजित नहीं करना है हमें. We are not going to make the statement अतिरंजित. We are not going to lose the degree of the statement. Superlative is enhancing the degree of the statement, enhancing the enhancing the quality of the facts. The qualitative enhancement of the facts should not be done so that it appears exaggerated or superlative. It should be in the same degree what exactly the facts are. Don't exaggerate them. Just be there to narrate what exactly it is. And then your interpretation also should not have any exaggerations. They should be very much related to the facts. So there should not be any exaggeration while using the language for the narration of the facts. So that ultimately you should note the facts observed by self and as it is. Whatever you have observed, that only has to be narrated very well, remember. That which you have not seen, that which you have not observed, like somebody else has done the PM, and then you are going to face the interrogation in the court. No, if you have written the report, if you have prepared the report after observing the series of observations while doing the postmortem examination, and then you have only prepared the report, then only you face the interrogation over such PM report. Somebody else has observed the case and you are facing the case. No, don't do that. If you yourself have observed the facts, then only you should state the facts and narrate the facts. That you have to remember very well. You can very well refresh the memory whenever necessary. Like you can go through the document. You should have a Xerox of a document which is already submitted to the court. So they have a document in their hand. You also have a document in your hand. You can go through the document once again, refresh your memory. You can refresh the facts which are denoted in that report. And sometimes you may need a text or a reference books so as to make a technical explanation over these facts. So you may not every time remember the text or the reference books as it is. You can have your reference books which are explanations for the certain case which you are facing right now, for the details of such case and the reported generated by you. The references may be in some treatise. You can refer those treatise or the reference granthas. You can always carry with you, and you can refresh the memory whenever necessary, and properly refresh the facts or the scientific facts rather, and then narrate the things without refreshing or just vaguely remembering something and then taking a chance of believing on your memory. Please don't do that. Refresh your memory whenever necessary, and then only go for further narration which you need to do. Avoid discrepancy between your earlier statement and your testimony in the court. Whatever document you have already submitted, that document and your statement in the court should be having an equal value. That should not have a difference in both the statements. Your oral statements and your earlier documentary statement should not have a discrepancy, should not have a difference in narration. So whatever is narrated in your documentary evidence which you have submitted earlier should very well match to the testimony or whatever narration you are right now giving as an explanation in the court. So there should be no difference, there should be no discrepancy. So avoid such discrepancy between the previous statements and the current narration in the court. Do not evade the question. Do not avoid the question. Somebody has asked you, some lawyer has asked you a question, and you are just making it aside and then going further for your own narration. Don't do like that. If you have any ambiguity or if you have not understood, or even if there is no such thing, but a question, every question has to be answered properly. If you don't understand the question, you can always ask to repeat the question. But as you have not heard or you have not understood the question, you are just bypassing it, you are evading it, avoiding it, and then going further for your narration as it is. Don't do like that. You can always request to repeat the question, understand the question properly, be attentive while again understanding the question, and then, as we stated earlier, attentively answer the question which is put forth by the court, by the lawyers. If you don't answer to particular question, like if you don't know, for example, if you don't know the correct relevant information for the particular question which has been asked, be frank to admit it that you don't know the correct facts related to that question, and admit it that you are not knowing the facts, and just then only you can deny answering the question, admitting that you are not very sure about the facts. Just don't ignore the question like that only. Be frank enough to admit that you are not knowing the facts regarding this particular question, and then only you can put forth your asamarthata to answer the question. Again, same thing further. If you disagree with any point, be firm, don't argue. Like sometimes, especially in the cross-examination, the lawyer will insist you to agree something, what he wants to get agreed from you. And probably that is something differing from the point which you have made earlier. So if you disagree the point which is raised now by the lawyer in the cross-examination, probably many a times such situations will arise, be firm on your own point. But at the same time, while remaining firm, you should not argue. Just admit plainly that you are stating this and this fact only, and you don't mean anything else. That head should be narrated very firmly, but no argument has to be made. Because always remember, the argument is contempt of court. You are dishonoring the court. So no arguments should be made while narrations. Do not lose temper. Remain calm and composed and courteous. Remember, losing the temper is a very bad presentation on your side. As an expert, you are, and as a doctor, you are a very respectable person in the society. And if you lose temper and narrate in that hot temper, something improper may be narrated. So remain calm and composed, and be very courteous, means very courteous to the court, to the situation around you, and remain calm and without losing temper. Even if there are leading questions which will agitate you probably, which will irritate you probably, which will lead to make you narrate something which is not a fact, it is pressurizing you to narrate probably which is a wrong thing, but it is favorable to somebody else. But still don't lose the temper. Be very calm and narrate, and be firm on whatever you are narrating as it is. Irritating questions may be asked to take the doubt over your honesty and credibility. In such situation, a doubt will be raised to just lose the solidarity of your character, just to lose the solidarity of your honesty and your credits. Such questions, which usually are there in the cross examinations, they may irritate you. They may take a doubt on whole creditability of your existence. But in that situation also, be cool. Don't get yourself irritated. Don't lose the temperature. Be calm and composed and still be firm on your point and narrate the same thing without losing any temper. Once you lose the temper, probably wrong words will be used and it will the whole essence will be probably lost, and you may land in a wrong situation where you may narrate something which actually you don't mean in that hot temper. So don't lose your temper. Even if somebody doubts you, even if somebody doubts your credits, even if somebody doubts your honesty, still be firm, be honest again while narrating, and be cool, and you continue your statement. Don't volunteer any statement, any additional statement which is not related to the case or which may not rightly be now probably proper to utter it right now. Such statements should not be volunteered. So don't volunteer anything new to be introduced. Only just be precise in answering the facts, narrating the interpretations of the facts, and an inference probably which you may need to narrate there as a expert. Be very precise only on that. Don't volunteer something additional which is not related to the facts which you have observed. So don't land in in a wrong situation by doing these things. Be always honest and impartial. Whatever you are narrating, the whole essence should be like that. You are very honest. You are not on any side, on any of the party, either the accused or the probably another party, whichever it is. Two parties which are right now contesting with each other, and they may are seeking for justice. Don't be on any side. Don't be on any party's side. Be impartial. Be very precise about your own facts, what you have, which you have observed. They may be probably helpful or favorable to some party, and they may be unfavorable to some another party. But you should not be bothered about its favorability to any of the party. You should be impartial. You should be honest enough always to narrate the whatever facts which you which you are knowing or you have observed. So in a whole essence, what I would like to suggest as an you can say a SAR, you can say a output of all this discussion, we should always remember that you as a doctor are always a man of science. You are a man of science. You have to help a court for admitting the justice, and you are not the judge. You are only a scientific expert. You are not the judge, and you are there only for helping the court for admitting the justice, which is said there for admitting or facilitating the justice. And that is the only role which doctor has to play. In essence, you have to remember this very well as a scientific expert and not as a judge. Thank you. Thank you. Uh, with warm wishes to all the further series of the Hrudayavarana webinar from Postgraduate Department of AGAD Tantra, Dr. D.Y. Patil, College of Ayurveda and Research Center, Pune, I extend wholehearted warm wishes for the success of the whole webinar, which is to be carried out till 15 September. Thank you. Thank you, one and all.
Thank you, madam. It is a time for the discussion.
Yes.
And if you have any doubts or want to discuss any points regarding the today's session, please. For kind information to all the participants, if you want to ask or discuss any point, you can unmute yourself and may ask the questions.
Yes, you can. They can ask directly also, even if they have not put their questions in chat box. They can right now also discuss and put their questions if they have any queries.
Yes, ma'am.
Probably the topic is quite clear. Yes, anybody wants to ask?
Namaste, ma'am.
Yes, namaste.
Can an Ayurvedic doctor can become an expert for court proceedings?
Yes, whatever you are observing, see, you are doing job as medical officer also. Government recruits you as a medical officer. And in such cases, there is no difference between an MBBS and a BMS doctor. You are there, they will not differentiate regarding your duties. You are entitled to do the same duties what any medical officer is entitled to do. So there is no difference. You are entitled to do every duty and sometimes to be a witness also whenever needed. So there is no difference. If you are observing a case and if you are there involved as a doctor, you are there to assist the legal procedures.
Thank you, ma'am.
Anybody else?
Any of the participants want to talk with ma'am? You can unmute yourself and proceed. There is no any question, madam, from the
Okay.
participants, from even in
Nice.
the Zoom meeting also, in the YouTube also.
Okay.
Shall we end with the session, madam, with your
Yes,
kind
yes,
permission?
sure.
Few minutes, sir, ma'am.
Yeah, pardon?
Nothing, madam.
No.
Good afternoon to all. Today we completed the second day, session third, national webinar series 1, Hridayanava 2020. Today we had a session on a doctor's role in legal procedures by Dr. D.O. Sunila Madam, the Professor and HOD, Department of AGAD Tantra evam Vyavahara Ayurveda by D.Y. Patil College of Ayurveda and Research Center, Pune. It is the end of today's session with a vote of thanks. Myself, Dr. G.N. Kannoli, the Assistant Professor, Department of PG Studies in Samhita Siddhanta, SVMAMC, ILKAL. First and foremost, in my privilege to thank with the blessing of His Holiness, Sriman His Holiness Pratasmaraniya and Dr. Mahanta Swamiji, and one more, Sriman Niranjana Pranaswarupi Guru Mahanta Swamiji. As the event started with the Swamiji's blessing, thank you, Swamiji. I thank to our SVMVV Sangha Chairman, Secretary, all the board members for providing an opportunity and giving support to this conducting a national webinar series 1 Hridayanava 2020. Thank you, sir. I thank our today's speaker, Dr. Sunila, Madam, the Professor and HOD, Department of Agritantra Evam Vyavhara Ayurveda, DY Patil College of Ayurveda and Research Center, Pune, Maharashtra. Madam had took a talk on the doctor's role in the legal procedures. As Vaidya is need, all the knowledge should be covered as per the society is needed and even the professional is needed. Madam had conducted fully with knowledgeable and enhancing the power of our knowledge also. Thank you, Madam. I thank to our event president, Dr. K.C. Das, sir, the principal and the CMO of SVMAMC ILKAL, for his kind-hearted care and being the backbone of this national level webinar series 1 through the year number 2020. Thank you, sir. I thank to event organizer, Dr. L.K. Pattar, sir, the Associate Professor and the HOD, Department of Agritantra Evam Vyavhara Ayurveda, SVMAMC ILKAL. Thank you, sir. The organizing for the national level webinar series 1 Udayatama 2020. I thank the event coordinator, Dr. Srimati Manjula P. Sarganachari, Madam, the Associate Professor, Department of Agritantra Evam Vyavhara Ayurveda, SVMAMC ILKAL. Thank you for the supporting and the conducting National Webinar Series 1 Udayatama 2020. I extend a thank to all the teaching staff and the non-teaching staff and PG and UG scholars, internees of SVMAMC PG Research Center, ILKAL, for supporting and being the part of a national level webinar series 1 for the year 2020. Thank you all. I thank the Department of Agritantra Evam Vyavhara Ayurveda, DY Patil College of Ayurveda and Research Center, Pune, Maharashtra, for their support and being the part of today's session, a national level webinar series 1 for the year 2020. Thank you. I extend the thanks to all the participants and the teachers, PG, UG scholars of other institutions, especially DY Patil College of Ayurveda and Research Center, Pune, Maharashtra, SVM Ayurveda Medical College, ILKAL, the participants watched in the YouTube for being the part and participated in this national level webinar series 1 with the year 2020. Thank you to all the participants. Lastly, I thank to the people who helped directly, indirectly in organizing and conducting this national webinar series 1 with the year 2020. Thank you, one and all. Thank you.
Thanks, sir. Thanks a lot, sir.
Thank you, madam. We'll end the session, madam.
Yeah. Shall I quit?
Yes, madam. Please.
Okay. Thank you. Thank you very much.
Thank you.
And best wishes.
Welcome, madam. Thank you.